Welcome, everyone, and thank you for coming to attend CPSC's Compliance Program Seminar. We're excited to see so many people in attendance, both from outside the agency as well as internally. I wanted to take a second to recognize Acting Chairman Burkle for attending, as well as representatives from all of the other commissioners' offices. Additionally, we have with us Rob Kay, the Director of Compliance and Field Operations, Jim Jaholski, the Director of Import Surveillance, and Shelby Mathis, our Small Business Ombudsman, as well as Patricia Hands, our General Counsel. Before we get started, Acting Chairman Burkle is going to provide some brief opening remarks. We're then going to have three panels. First, CPSC staff is going to present on the nuts and bolts of compliance programs. Second, we have representatives from firms who will present on their compliance programs and discuss how their programs work. And third, representatives from industry trade groups will present on emerging trends and compliance issues that are of interest to their members. In order to keep things flowing and finish in a timely fashion, we plan on moving through all three panels and taking questions at the end of the program. There are restroom facilities and water fountains outside the guard's desk by the elevators. Finally, at the conclusion of the seminar, we'll send you an email with a survey, and we appreciate any and all feedback you can provide. Please welcome Acting Chairman Burkle.
Thank you very much, and good morning to all of you. Welcome to the Consumer Product Safety Commission and to our Compliance Program Seminar this morning. For anyone in this room who's been under a rock for the last couple of years, I'm Anne Marie Burkle, Chairman of the Consumer Product Safety Commission, and I do want to welcome all of you here this morning. And I want to thank Office of General Counsel and the Compliance Office and all of the staff who have really worked very hard to put on today's seminar. I want to thank all of the staff for their work here today. The subject of today's seminar is compliance programs. Oftentimes when a company or a firm works with our agency, it's because they either had an inadequate compliance program or they didn't have one at all. There's no question that a good compliance program can identify any problem much earlier in the process, and it can prevent any serious injury to your customers. It seems that a good compliance program should be really a part of any safety program. Our goal today is to give you some ideas for developing a successful compliance program or improving one that you might have. We have speakers from within and outside of the agency who have much experience with compliance programs, some good and some that may have fallen short. But good compliance programs have similar elements. But this is not a case of one size fits all. Different firms may have different compliance programs, but they may work very well. What's important is that you are the experts. You know your staffs, you know your talents, you know your products. And so it's important that you tailor the program to meet your own needs. But my hope for today is that you all leave with new ideas and a better appreciation, really, of the benefits of a good compliance program. I hope that you will share your ideas with us, not only today, but in the future. As chairman, and I think you all know this about me, my main goal, and one of my main goals since I've been chairman and even as a commissioner, is that we have productive dialogue, whether it's with this matter or any matter. Because I think that it's important that the private and the public sector continue to talk. I think that we can really affect safety if we have this productive dialogue and we can use each other's expertise and our strengths. I think we can be far more effective when we work together. I want to thank you all for coming today. I hope that you find today productive and meaningful. I know the agency will. I know our staff will. I know we will learn from you. And I hope that we will learn from that you will learn from us as well. And I look forward to your active interaction today with us, and I look forward to the program today. Thank you all very much for being here.
Thank you, Chairman. Our first panel is comprised of CPSC staff. First to speak will be Mary Murphy. Mary Murphy is the Assistant General Counsel in the Division of Compliance and will discuss the legal basis for compliance programs as well as what these programs should include. Next, myself and my colleague Lauren Kleinman both attorneys from the Office of General Counsel, Division of Compliance, will speak to compliance programs best practices. Third, Tanya Topka, the team lead of the electrical, fire, and mechanical team, will present on reverse logistics and the importance of adequate notice throughout your supply chain. And finally, Carolyn Manley, the team lead of the Children's Regulated Product Team, will present on regulated product issues to be addressed in compliance programs. I will now turn things over to Mary Murphy to begin our program.
Thank you, Noah. Good morning. Attorneys in the Office of General Counsel, Division of Compliance, investigate and negotiate penalties with firms for violations of Section 19 of the CPSA and other acts administered by the Commission. And in the course of those investigations, we evaluate the facts in light of the civil penalty factors contained in the statute and also the implementing regulations. And one of those factors is whether or not the firm had at the time of the violation an effective and reasonable compliance program. Now, while we've never been in a position to either develop a program for a firm or to approve a program once it's been developed, we have seen firsthand in those cases what can happen when a firm doesn't have a program or when an established program is not effective. So the purpose of this presentation is impart to you the sources of information contained in our statutes and our regulations that will help you identify elements that you may want to include in your compliance program. First, why should you have a compliance program? Not just because we say it's a good idea, but I think it's because there's a win-win. There's a benefit to consumers, there's a benefit to the firms. Obviously, the benefit to consumers is that you ensure that the products that you produce and that you manufacture or sell are safe for consumers. The benefits to you are very significant. If you have a proactive program that begins early in the process, at the R&D programs, for instance, you ensure that from the very beginning you have design and testing during the research and development process through the manufacturing and assembly process so that you can then easily identify an issue or a safety problem that may come up during that process. And in the event you may find that a product that you've produced and sold does have a safety issue and you have to do a recall, you already have a process in place so that you can easily and effectively implement a cap and a recall. It's much better to do that than trying to be reactive if you're notified by the Commission that, for instance, we need a full report, or you report to us and indicate that you have to pull a product off the market. The advantage to doing that is that you have smooth sailing. And then you avoid missteps. And we'll hear during the course of several of these presentations, some of the most significant missteps we've seen have been once a product's been recalled and we think the product's removed from the market, but we identify issues in the reverse logistics program that don't in fact remove those products from the marketplace. Another advantage to having a compliance program that's reasonable and effective is that you stay out of our crosshairs. As we said, one of the penalty factors is an effective and reasonable compliance program. So if you have that program from the very beginning, you're less likely to not timely report or commit a violation of Section 19. In addition, another civil penalty factor is whether or not you have a prior civil penalty. So if you avoid it in the first place, you also avoid the applicability of that second factor to you. We have seen the need for compliance programs, as we mentioned, in our civil penalty investigations, particularly for timeliness. And the reporting obligation is contained in Section 15B of the CPSA. It requires that a firm immediately report when it obtains information which reasonably supports the conclusion that a consumer product fails to comply with an applicable consumer product safety rule or a voluntary standard relied upon under Section 9 of the CPSA. There's only 2 of those for chainsaws and gas-powered room heaters. Whether or not the product fails to comply with another rule, regulation, standard, or ban under the CPSA or other acts enforced by the Commission. There is a really helpful chart on our website under the Regulations/Laws section that is a chart, and it identifies by product. And if you go to it and you sell a particular product, you can see next to it what the applicable regulations are. And in many cases, there's informative guidance that goes with that. So I would direct you to that. The other reporting obligations are whether or not a product contains a defect which could create a substantial product hazard, or whether it creates an unreasonable risk of serious injury or death. And we'll talk a lot about those latter two elements. A failure to comply with Section 15's reporting obligation is a prohibited act under Section 19, and penalties can be imposed for knowing violations of those. So, how can not having a compliance program lead to a knowing violation? Well, the definition of knowing in our statute is actual or presumed. Actual is pretty straightforward. Presumed is kind of a should-have-known standard. But the statute says, or the regulations say, that it is the knowledge that a reasonable person who acts in the circumstances would have upon the exercise of due care to ascertain the truth of what's going on. So, if you have information from various sources coming into your company, but you don't have a process to collect it and analyze it and then elevate it to the right people on the safety team who have the ability to act, you can commit a knowing violation. So the objective of having a compliance program and of this presentation is to help you get in front of that scenario. You have to ensure that the right people at your firm are informed of safety information and that they have the authority to file a report. So the way we've broken this down is so that you consider compliance programs in terms of who, what, and when. When we talk about who should have a compliance program? Obviously, everyone's subject to our jurisdiction: manufacturers, importers, distributors, and retailers. But who are the people at a firm who will be considered to have information for purposes of whether or not there's a knowing violation? It's important to understand that it's not just the person to whom the report is made. There is a regulatory section that talks about imputed knowledge. So you cannot silo information in particular divisions. A firm is deemed to have obtained reportable information when safety-related information has been received by an official of the company who can reasonably be expected to be appreciating the significance of that information. What we've seen is cases where information goes to, for instance, the engineers, or it may go to the customer service department, and it may stay there. Or it may be used for purposes of determining from an R&D standpoint, do we need to make changes to this program? Do we need to take some kind of action with respect to quality? But it's important to recognize that there are dual paths, that information should be elevated to people for all purposes through the company to determine whether or not you want to make changes to the product, but also to assess whether or not you have enough information that has triggered a reporting obligation. The regulations, as I said, don't account for compartmentalizing information. In fact, under ordinary circumstances, it is assumed that safety-related information that comes into a firm reaches the desk of the CEO within 5 days. Now, who should be a part of your compliance program is really your call. It depends on the structure of your firm. It depends on your size, a lot of factors. The individuals that we've seen that have been members of compliance programs include safety or quality staff, customer service personnel, risk management individuals, engineers, and general counsels. So the compliance program should include people who will know what to do with that information about safety-related information when they receive it. So now the what. What kind of information should you capture and analyze, and then what should you do with it? Well, again, we look to the regulations that talk about the same elements that are applicable to reporting obligations and penalty considerations, because if we're looking at it, you should be looking at it for your compliance program. You're going to want to know whether or not your product is in non-compliance with a rule, regulation, standard, or ban, or whether it contains a defect or an unreasonable risk. The sources of information and the elements that you're going to want to capture are contained here on this slide, and they include things like engineering and production data, quality control data, and I would just suggest to you that you not compartmentalize or characterize quality data as something that cannot be important for safety-related considerations. It may well advise you that there are some safety concerns associated with your product, but they may be categorized as quality information and you may ignore them, and that may be a mistake. Have you made design changes to a product, and have you done so because of safety-related considerations? What we've seen in some cases is that the firms have gotten in a number of incidents and injuries, and then they've made the design change. So if that information was significant enough for you to consider making a design change, that's information that should get serious consideration from your compliance team. Do you have product liability suits or claims for personal injury and property damage? Do you have information from independent test labs that suggest you may have a safety-related issue with your product? The largest source of information that we seem to see is information and incident complaints from consumers or consumer groups. Sometimes you will get information from the Commission, or sometimes you'll get it from other agencies. And if you get a letter from the Commission where we have sent you, for instance, an IDI as a manufacturer, it'll be accompanied by information that says you need to look and see whether or not this information that we're giving you, in combination with other information, creates a reporting obligation. I would suggest to you that that should trigger at that point a look back internally, because if you get one of those letters and you haven't thought about whether or not you have any kind of issue associated with that product, you should at least stop. And if you have a program in place at that point, you can go and collect all the information about that product and then do an assessment about whether or not some kind of action is required. Information about returns for products. When customers return products, sometimes we have information that they returned it for reasons we don't know. I would suggest to you that you might want to capture that information. I don't think you should discount it or suggest that people are returning it simply because they want their money back. People may be returning it because it blew up, or it cut them, or it has a problem that they don't want to keep anymore. And if it's a safety-related issue, you really should capture that information and impart that to your team so that they can assess it. Warranty claims are also things that come in. Again, you just have to be careful that if it's characterized as warranty claims, it should also be considered and assessed for determinations of whether or not it also imparts to safety regulations or violations of safety laws. And pre-market and production testing. You might want to consider those if you are looking at information that you have about a product and you look back at your pre-market and production testing. Are any of the incidents or the concerns that you have now taking on special significance because of things that might have been raised as red flags during the pre-market testing? Other information that you're going to want to capture are also things that have reporting obligations associated with them in our statute and regs. If you have a death or grievous bodily injury, obviously that's important information for your compliance program to take advantage, to look at, to consider whether or not action is required. If you sell a toy or a game that has marbles or small balls, balloons, or small parts, and a child chokes, dies, is injured, stops breathing, or has medical treatment, you have to report that. But obviously, again, that's one of those incidents where your compliance program ought to take a hard look back at what you have. And finally, if you have 3 settlements or verdicts within 24 months involving death or grievous bodily injury, Section 37 requires a report within 30 days. My advice is don't wait for that third incident to happen, because in fact the regulations provide that the Commission would expect you to report long before that, because you probably have information in your files that suggests that there's a safety-related issue associated with that product. And if you sell your product outside of the United States, you also want to consider whether or not incidents and injury information or other data associated with the use of that product in those locations is relevant to whether or not the product creates a safety-related problem here. That should all be captured as part of your compliance program and considered. So once you capture that information and the information you determine concludes that there's a noncompliance or a defect. Oh, I'm sorry, I've gone ahead. Once you collect that information, what do you then next do? Well, you determine whether or not there's a defect. The regulations have a very broad definition of defect. There is a dictionary definition, a fault, flaw, or an irregularity. There is also the potential for a defect to be found in the manufacturing and the production, in the contents and construction and packaging and warnings and instructions, and also in the design of a product. If your assessment determines that there is a noncompliance or a defect, the next thing that your compliance team should do is determine whether or not it creates a substantial risk of injury and thus a substantial product hazard. If you do this analysis, you simply look to see whether or not any one of these 3 factors is applicable: the pattern of defect, the number of defective products, or the severity of the risk. When your compliance team is looking at pattern of defect, you simply assess what are the conditions under which this defect manifests itself. When you're looking at the number of defective products, the idea is that if there's a lot of products out there, there's a lot of consumers exposed to this risk. But the converse is not necessarily true, because even one defective product can present a substantial risk of injury if the injury which might occur is serious or likely to occur. And then you look at the severity of the risk. A risk is severe if with the injury which might occur is serious and or likely to occur. We're going to talk about what a serious injury as defined by the regulations is in a minute. But if you're looking at whether or not an injury is likely to occur, you look at several factors, and these are set forth in the regulations. The first is, what is the number of injuries reported? The second is, what's the intended use or reasonably foreseeable use or misuse? And whether or not you have a vulnerable population who's impacted by this product. It's easier to do this analysis if you are proactive and you have all of that, because of your compliance program, the ability to collect all of that information and then know, okay, now we have it, what do we do with it? So if you have SOPs that you've built into your compliance program, it facilitates the efficient evaluation of this information, and then perhaps if you have to report, a timely report. But after that assessment by the compliance team, if you determine that there's no defect that poses a substantial risk of injury, are you done? The regulations say that you're not, right? You have to report if you have information that reasonably supports the conclusion that the product creates an unreasonable risk of serious injury or death. So how do you determine if a product creates an unreasonable risk of serious injury or death? You collect certain information, just like you do for defects and noncompliance. These again are taken from the regulations, and some of them you will see overlap with the ones that you should consider for purposes of defect. All of them, though, you should already have together in your compliance program in collecting them, putting them in one place, allowing the compliance team to evaluate them. So for this section, you talk and you look at, do I have reports? Do I have test reports that might indicate there's a safety-related problem? Do I have reports from experts? Specifically, do I have, in connection with litigation, expert reports? We look at those. You should look at those. All of this is information that we look at, so you should look at it as well. What kind of claims do you have? Again, do you have product liability claims or lawsuits? Do you have customer complaints? And not just customer complaints of injury, customer complaints in general, from dissatisfaction with the product to I was injured by the product. Do you have insurance claims or payments? Now, this is something we hear from firms sometimes, that they don't think that the fact that they paid an insurance claim or a settlement should be relevant. And it's not an admission of liability, and we don't consider it for that purpose. But what we do consider it for is knowledge. Because if that is information that was assessed and evaluated by your insurance company or you internally, then there is clearly knowledge of that incident that might reasonably support the conclusion that that product creates an unreasonable risk of serious injury or death. You should also assess whether you have data and studies, quality control studies. Again, quality issue to one person may be a safety issue to another. And do you have science or epi studies? External information, again, is something that you should collect in your compliance program. In addition to information you may receive from the Commission or from other government agencies or consumer groups, sometimes we've seen that retailers have sent letters to other companies and said to them, we've had a problem with consumers returning this product because they have had reports of dissatisfaction or injury, and you may want to consider whether or not you have a reporting obligation. This is sometimes contained in the retailer letters. I would suggest you take a second look if you get one of those letters. Look back at what you have about that product, which will be really a lot easier if you already have the program in place to do it. And finally, if you have a verdict that's been rendered in a case in which your product was found to have caused serious injury or death, that kind of information warrants special attention from you because it significantly gets attention from the Commission. The Commission will attach considerable significance if a firm learns that the court or jury has determined that its product caused a serious injury or death, and a reasonable person could conclude that the product creates an unreasonable risk of serious injury or death. So, for purposes of determining whether or not the information you have and that you've gathered from your compliance program creates a serious injury, what is a serious injury? It's set forth in the regulations. It's a grievous bodily injury, an injury requiring hospitalization, medical or surgical treatment, or even treatment that's, broken bones, fractures, stitches, I guess now glue, concussions, injuries to the eye or ear that require medical treatment, and whether or not the person had to miss work or school for more than a day as a result of this. You also want to consider not just immediate injuries, you want to consider long-term and chronic health consequences as a result of this. You also want to monitor in your compliance program standards and ensure that you comply with standards. It's important to recognize that even if you comply with a mandatory standard, that doesn't mean that you may not have a reporting obligation if the information suggests that the product has a defect or a risk. The fact that you comply with that, however, will be taken into consideration by the Commission or by the compliance team in determining whether and what type of cap will be required. So finally, when? Now that you've collected all that information, you have the members of your compliance team in place, when do you have to act on that? The reporting obligations require that you act immediately. That's 24 hours. You should not wait for information to pile up till it gets to a critical mass and then you determine that we have no other option except to report. You are given 10 days to conduct an investigation, but you should understand that even if you don't look at any of that information, at the end of those 10 days, the regulations provide that you will be assumed to have reviewed and considered it. So you don't want to keep your head in the sand. You want to keep the compliance team monitoring what's going on with incident, injury information, all of the other sources of information. And then when you have it, determine what are we going to do about it and how quickly do we have to act. If you do that, then you're less likely to see a reporting violation. So now that you know who should have a program and what you should do and what you should collect and analyze and when you should take action on it, Lauren and Noah are going to tell you the really important part of this, which is how. The how you put a compliance program together by discussing the best practices for developing and implementing a compliance program.
Good morning, everyone. I am going to take you through steps 1 through 5 on our 10-step presentation for developing an effective compliance program. I will then turn things over to my colleague, Noah Anstrauss, who will pick up with steps 6 through 10. When developing a compliance program, firms will want to create a system to collect and consolidate information to ensure that the information is properly analyzed. Step number 1, establish a culture of safety as the foundation. Safety is something that must be integrated and practiced throughout your firm each and every day. A firm must ensure that the right people and structure are in place for the compliance program to be a success. Firms can develop a culture of safety through training and practice. Training is essential because without adequate training, the best written policies and procedures will not be effective. In addition to new employee and new assignment training, biannual or annual refresher training is something you will want to complete. Firms will want to practice and audit their procedures to review and evaluate their compliance program in order to facilitate its continuous improvement. A regular review that incorporates lessons learned from audits will ensure that training is effective and not merely a box to check off. Step number 2, create written standards and policies. You'll want to tailor your program to the individual needs of your firm. Establishing and maintaining a system of internal controls and procedures will help to ensure that a firm promptly and accurately reports required information to the Commission. Such a system will enable firms to remove unsafe products from the marketplace and potentially limit product liability litigation. Problems can arise when firms do not have a written compliance program. Specifically, we have seen firms without documented procedures receive consumer complaints, lawsuits, and other injury information that was not tracked or evaluated in any logical manner. Consequently, in these circumstances, reporting to the Commission was delayed. Firms will want to make sure that all employees and other relevant parties, including but not limited to distributors, suppliers, and third-party logistics providers, are aware of and understand their individual role in your compliance program. A compliance program should not be static. The program needs to grow and evolve with your firm. A periodic assessment can help to identify gaps or program adjustments that may need to be made due to changes at your firm or in the marketplace. For example, if a firm changes its organizational structure, makes an acquisition, enters markets and new channels, brings on new third parties, that firm will want to make adjustments to its program accordingly. As part of a compliance program, firms will want to have a recall plan in place to enable quick action when necessary. The ISO standards may provide guidance on developing a compliance program that includes a recall plan. Step number 3, supplier qualifications and audits. If your firm is doing its own designing, making safety a priority at the design stage will allow you to identify problems prior to sale. All firms will want to have procedures in place to confirm that testing to each and every applicable standard is completed and documented for all products. Often, we encounter firms that do not conduct independent testing, but instead rely solely on the testing conducted by their suppliers. Some common problems with this approach include the following. First, a product being introduced into commerce is not the same product contained in the test report. For example, your firm is selling a blue truck, and the test report from your supplier mentions a red doll. Number 2, test report dates are old. Please note that report dates older than 1 year are considered suspect. A firm will want to establish a testing protocol so that products are tested periodically. Periodic testing can help with golden sample issues where a supplier provides a nearly perfect sample for initial testing, but the units produced and distributed are different. Specific to this point, we've seen changes that can occur in the manufacturing process, such as lead paint in children's products. This is something that may not be caught when initial testing is conducted, but it could be caught through repeat testing. And thirdly, we've seen products that are tested to the wrong standards. Firms will have passing test reports for products that passed EN standards as opposed to US standards. Some firms choose to address these problems by ordering their own testing, either routinely or as audits, to verify the accuracy of their suppliers' reports. It's very important that firms exercise due care when relying on a supplier. Firms will want to take the following affirmative steps. 1, include contractual provisions requiring compliance with specifications and quality programs. 2, visit manufacturing locations. And 3, spot check products for ongoing compliance with safety requirements. Step number 4, establish an information collection protocol. Firms will want to establish systematic procedures for collecting the information to be reviewed and evaluated for potential safety issues. You will want to consider multiple sources of information. These different sources were previously specified during Ms. Murphy's presentation, and I want to now highlight the types of incident information a firm will want to collect. This includes the date of report, complete consumer contact information, the product name, make, model number, serial number, date code, and any other identifying information on the product or packaging, along with incident details. Incident details are probably the most important. You will want to record the date of incident, all circumstances surrounding the incident, along with any injury or medical attention details, and photographs and medical records when available. More is better in this situation. You will want to collect as much information as possible. For example, we've seen cases where firms will collect just incident samples and have no information surrounding the incident circumstances. This is problematic because a firm will not have a complete picture when evaluating possible safety issues. Additionally, it is very important to provide clear intake instruction to all individuals who will be collecting incident information. We have seen problems arise when firms utilize third-party call centers to collect this information because those employees are not always trained in the same fashion as the firm's employees. Third-party call center employees must be trained in how to collect information and escalate calls based on the firm's compliance program. For example, they should be trained to recognize trigger words based on product categories, along with any other guidelines the firm has in place regarding when to escalate calls. Step number 5, have a central database. A central database will provide a firm with a place to store all safety-related information so that once the information is collected, it can be reviewed and analyzed promptly. You will want to make certain that your databases speak to one another. For example, going back to issues we've seen with third-party call centers, you will want to confirm that an incident database that your third-party call center has routinely transmits information to the firm. When reviewing cases for civil penalties, we have seen firms that use call centers that are not integrated with the firm's operations. In these situations, we've seen key information either not make it to the firm or arrive late. Therefore, something to keep in mind is setting up a protocol for how often these complaints are transmitted to the firm. Next, you will want to ensure that employees are trained to recognize safety-related issues. Although technology is helpful in screening and storing information, it is ultimately people who make the decision when to report. The central database should not only include consumer incident reports, but it should also include quality claims, warranty claims, returns data, repairs, in addition to all other sources of safety-related information. For example, even an accounting database contains safety-related information that could be useful for uncovering post-recall sales or unusually high rates of return that may have safety implications. When we review a case for civil penalties, we will consider all sources of information that were available to a firm. Staff will not limit its review to simply the information that the firm chose to consider. I will now turn things over to Noah Anstrauss, who will pick up with step number 6.
Thank you, Lauren. Step number 6 is to create a system for employee reporting. Safety issues are going to eventually surface. It's best to get ahead of this process and know what your employees know when they know it. During an investigation, the information your employees have is likely to come out. You need to get ahead of this information. We recommend, especially for larger firms, that there is a way to confidentially report safe information. The goal is to make employees feel safe reporting potential safety issues. By having confidential reporting, this eliminates potential stress in the system and can help your employees feel safe reporting. By creating a reporting system, you're ensuring that safety information will get to the right people based on your organization structure. For example, if you have a large multinational corporation with multiple factories, labs, and divisions, a line engineer might notice a potential safety problem. Who does this person report to? If he reports to his boss, it may or may not get elevated depending on a variety of factors, such as the boss's interpretation of the information or other considerations such as production timelines. Even if that report goes smoothly, it still must be continuously elevated, either by the supervisor or the individual employee. Having a clear process in place for reporting eliminates this friction. It also ensures that this report gets directly to your safety department where it can be of most use. Step number 7 is to have senior management responsible for compliance. By making senior management responsible for the compliance program, you can help create the culture of safety we've discussed. If management is not involved and consulted, the best written program can still fail due to a variety of factors, such as employee turnover, overworked employees, and people working in areas that are not their specialty or they're not trained in. Who from management should be involved is obviously up to each firm and is dependent upon a number of factors, including the size of your firm, the geographic areas of distribution and sales, the number of product lines sold, and your business structure. The more people who are responsible for safety, the more likely you are to foster a business atmosphere that is attentive to and responsive to safety issues. The following are some of the benefits of having management involved. You can ensure that the prompt disclosure is made to the firm's management of any significant deficiencies or material weaknesses in the design of operation of your compliance program or other internal controls. Additionally, without at least one senior member of management having a focus on safety, even if a non-managerial employee discovers a potential issue, it can be hard to get that information in front of an individual who can effectuate change and take care of the issue promptly. Having senior management involved also avoids the issue we have seen where a single non-managerial employee has been put in charge of making the decision of whether to file a Section 15 report or not. Whatever a firm's safety review process, it's important to not allow incidents to pile up without regular review. Firms should have a process that dictates when to convene safety committee meetings, which may, for example, depend on the number and frequency of different trigger words for different products. Obviously, this is going to look different depending on the structure of your firm and what you sell. The important thing is to make sure that you are reviewing these incidents in a consistent fashion. Step 8, we've previously spoken about CPSC's reporting requirements, but it's important to make sure these requirements are actually incorporated into your written compliance program. As part of your compliance program, your firm should have procedures on all aspects for filing a Section 15 report. Staff has set up a website for filing Section 15 reports at saferproducts.gov, but you can also email compliance these reports if necessary. Reporting firms should be prepared to provide the information required in both the initial and full reports. Step number 9 is you need to include a reverse logistics. You need a compliance program, Your compliance program needs to include a recall execution plan. CPSC provides step-by-step guidance online. There's a link on our slides. What we want to focus on now is reverse logistics, and in particular, how to stop the sale of recalled goods. What can be done to stop the sale of recalled goods? First, and most importantly in staff's determination, do not reuse SKU numbers. For example, if you have a certain model toaster oven that is recalled and replaced with a newer oven using the same SKU, it's going to be impossible to use the SKU blocks to distinguish between what was recalled and what can be sold. A firm is then in a difficult position when trying to block the sale of recalled goods, because if they keep the SKU block turned off, stores are not going to be able to sell all the new inventory that's piling up. As a result, the solution would be to turn the SKU block off. However, in that case, the firm's going to have no computerized controls over the sale of those older recall products that might still be in inventory. Relating to not reusing SKUs, think about changing model and serial numbers following a recall. While changing model numbers may not directly impact the sale of recalled goods, once again, if you have 2 toaster ovens, one recalled and one not, and they have different SKU numbers but the same model number, there's a chance your computer system should be able to tell those 2 products apart. However, you're going to create confusion in the marketplace and with your consumers because they're not going to know whether they have one of the new non-recalled products or they have one of the older recalled products. When something is recalled, we suggest you make a clean break. Give the redesigned product a new SKU and a new model number. While we obviously recommend not reusing SKUs and model numbers, we understand that sometimes the recall remedy is a product fix that involves making some change to the product and that makes the assignment of new SKUs or model numbers impractical. In these rare circumstances, you need to make sure that there is still some way to differentiate between the products. We've seen firms in the past apply stickers or some other mark on the product that's been fixed so that there's a clear delineation between the two. Our second point for preventing the sale of recalled goods is to test your computer systems to make sure that any of your warehouse computer systems, any different concept store computer systems you have, any cash register or point of sale systems you have, any internet sales platforms you use, and any third-party logistic provider software that you use all work as intended, and that a SKU block put into one system populates across all the systems as you anticipate. We have seen cases where a firm has successfully blocked the SKU in one of its main sales databases, but because this database didn't communicate with all of the other databases as intended, recall sales were still occurring. Don't assume that your computer systems are going to work properly. You need to test them. You need to test them not only when they're first installed and started, but as software updates roll out. We suggest you test these as many ways as possible. Our third point is to have a point person in charge of recalls and running reports, such as inventory reports and SKU block status reports. Related to this heavily is our fourth point, is to make sure that point person actually runs these reports and reviews this data on a regular basis. You need to make sure you review reports, especially on inventory status regularly, to make sure that all recalled inventory is actually removed from stores and all distribution channels. You can't just run this report once just prior to a recall, or maybe a couple times just prior and just following a recall, because we've seen that products can remain in your distribution channels for a significant period of time. Products have a tendency to reappear through returns, found items in old inventory rooms, and through items that were in transit at the time of the original recall. We have seen cases where stores have been selling recalled products several years past the date of the initial recall. We suggest you create a daily or a weekly inventory report for all products that have been recalled that you sold, and just run this report, have an employee assigned to check it, and they'll be able to tell fairly instantaneously whether you have recalled products in inventory, and you can get those removed. Finally, to the extent possible, you need to make sure that your register prompts, and really any time that a product is scanned, tell the actual status of a product if it's recalled, and not some generic error code like error code 22. If you have a cashier who's in a busy line and the customer in front of them really wants to buy this toaster oven for her grandmother's birthday later that day, and the cashier sees error code 22, they may or may not actually block the sale, but they might come up with some way to either override the SKU block or sell it as some other thing. However, if that register prompt says danger, recalled product, don't sell, or really anything of the sort, the chances of them blocking that sale increase significantly. Our 10th and final point is to make sure your firm has a record retention policy. Staff recommends that the policy be to keep records for at least 5 years. If you're upgrading your systems, you need to make sure that there is some way to access the older legacy data. Staff's often going to ask for this data when helping to analyze incidents. Retention of documents can help identify actions to ensure future safety and compliance. It can also help speed up the review process after filing a full report to CPSC. Documentation helps CPSC understand the efforts you made to provide safe consumer goods, what went wrong, and how it's been corrected. Thank you for your attention. Tanya Topka is now going to speak on reverse logistics and adequate notice.
Good morning. I'll be discussing reverse logistics and adequate notice. These two items, I guess I should probably change slides. That would help first. There we go. These two items are a very important part of any compliance program. One of the main pillars of a recall is to notify those affected. Companies should do work in advance as part of their compliance program to ensure they know what their messaging will be when issues arise and the communication avenues they will use. Companies should always ensure they have an adequate remedy or remedies for recall. Consider options or backup plans for remedies. For example, there's a small appliance recall that occurs in the week before Christmas. The company is only offering a replacement that is not available for 3 to 4 weeks due to production. This is a perfect example of when a company should explore another remedy, even if it is temporary, to avoid complaints that can happen and issues that can arise. Communication is key in both recalls and compliance programs. Communication breakdowns can lead to issues that can allow recall products to be sold after the recall. Here are some examples of communication issues that your compliance program should account for. Inadequate call center staffing or messaging that lead to long hold times or disconnects, or staffing that doesn't speak the language from where your product is sold. So if you sell your product in Poland but nobody can speak Polish and you get phone calls, that could be an issue. Consider online registration to reduce the influx of calls to the call center. We found this to be a very valuable way to reduce the number of calls coming in. And then if it's online, people can respond any time that's convenient to them. Call center staff should not give incorrect recall information. For example, somebody's calling a year after the recall and the call center says, well, this recall's expired. You can no longer get this remedy. Website issues that lead to crashes or inaccessibility. Also ensure that your website displays on mobile devices. Everyone uses their phones to get on the internet now, so make sure that they can access that information from their phones. Unclear instructions for returns or remediation. Failure to notify and give instructions to retailers that can lead to product being sold after a recall is announced. Not having the correct retailer point of contact for recalls. Don't reach out to a buyer to give recall information and safety information. Make sure you know who should get that information. And really, retailers should not find out about a recall from a press release. They should know about it in advance of that press release. The objective of any recall is to get as much recalled product without remediation out of the hands of consumers, retailers, and distributors as possible. Therefore, a reverse logistics plan for destruction and/or remediation is essential. To explain why reverse logistics plan is important to a compliance program, first we have to understand what it entails. Reverse logistics is the process of planning, implementing, and controlling the efficient and effective flow of goods from their typical final destination for the purpose of recovery or proper disposal. A company's reverse logistics plan should be one element of their compliance program. It should be comprehensive and have the flexibility to adjust as issues arise and adapt to the needs of the situation. Companies should develop a reverse logistics plan before they are in a recall situation and need it. If a company already has a plan, the company leaders should take a close look to ensure it is comprehensive enough to clearly guide employees and those involved in the recall through the process. Plans should be routinely rehearsed and regular mock recalls should be conducted to identify weak points and gaps so the plan can be adjusted and evolved to address issues that arise. The company's employees and business partners should know the plan and how to carry out their role. Through practice, the plan allows companies to identify exactly what should happen, who is responsible, and what role everyone has as part of that plan. Adequate notice should include alerting the whole supply chain, retailers, distributors, if it's a licensed product, the licensee, everyone should be part of that plan, and there should be detailed steps for each role. Provide specific instructions for disposition of recalled products. Provide a recall point of contact, not only with the recalling company, but also with each one of their retailers. You should know how to reach out to every one of your business partners. Ensure that everyone knows exactly what to do, their role, who to contact, and what notice should happen leading up to and including the recall announcement date, not after. When developing a reverse logistics plan, please consider and give thought to the communication avenues. Who will you be communicating with when issues arise? Where is that communication going? How or what method are you using to communicate with? And what are you communicating? These are all things you should be working out in advance of issues. Also consider quarantine and destruction of the product. How are you quarantining your products to ensure they are destroyed and don't end up back in the stream of commerce inadvertently? If retailers will be doing destruction at the store location, consider how you will have records and control over things like managers logging that the product was destroyed, they get busy, get distracted at the end of their shift, and forget to put it in the trash compactor. Employees seeing something in the back room next to the trash compactor, liking it, and walking out the door with it. Dumpster diving of people coming through the back dumpster of that retail location. Register coding that prevents returns from ending up back on shelves. So you have something that's returned a year later, very generous return policies, and it gets returned a year later, but it's recalled. How do you ensure that doesn't end back up on shelves? There is way more control over recalled inventory if the product is sent back to central distribution centers, location or locations that you have across the country for mass destruction. So definitely as a preference if you're trying to maintain control and ensure that you know what's happening with those recalled products. Consider computer limitations, some of which Noah discussed previously, but ensure that systems don't default to sell off or auction off quarantine product after a period of time, that enough notice and product identification is given to the retailers that you have, that they can put a stop sale lock on registers and that returns are accounted for in the system. Again, I hear time and time from retailers that say, I found out the day of the recall. There's no way I had time to put in a stop sale on this or a register lock or to get the product off the shelves. And the last thing you want is for a retailer to be selling recalled product because they didn't get enough notice. And lastly, ensure that destruction and recycling is witnessed and that there are records and controls in place to prevent employees at those locations from taking the product and selling it in the secondary market. Careful planning can help a company prevent common issues and mistakes from occurring. I will now be turning it over to Carolyn Manley to discuss the regulated perspective.
Thanks, Tanya. Good morning. Today I'm here to talk. Oh, let me change. Today I'm here to talk about compliance programs from a regulatory perspective and the common problems we see with regulated products. Purpose of a compliance program. Basically, it is to ensure that products are complying with the regulations and avoid enforcement actions from our office, the Office of Compliance. Now, in order to comply with the regulations, you need to know what the regulations are and know what regulations fall under what statutes. Now, here are a list of our statutes, and what's highlighted here in yellow are some of the common violations we see under those 3 statutes. Now, I'm going to talk about specific examples later, but let's talk about common problems that we see across the board. 1, products not meeting mandatory standards. Products not meeting mandatory standards may first be because you're not aware that there's a standard for your product. So it's key to make sure you know what products you have and whether the products have a mandatory regulation for it. Products being detained at the port. This is not the time to learn that your products have regulations. It will avoid costs of us detaining your shipment to evaluate to determine whether your products are in compliance. So if you have a compliance program, that will avoid having your products detained at the port while we evaluate your product. Products not tested to applicable requirements. If you have a compliance program, you can inventory your products, know what products are subject to what regulations, and then what products are applicable to, say, if they're children's products. What products are subject to, if it's a children's product, it's the consumer product and the consumer product. A children's product is subject to certain mandatory requirements. So if you know CPSA, you'll know what products are subject to the CPSA. So all children's products are required to have a children's product certificate, which we call CPC. So if you know that, you'll know what products are subject to the CPSA. Appropriate test reports. Sometimes we see test products that are not tested by U.S. regulations. Our Office of General Counsel's office talked about how to do a compliance program, what's needed in a compliance program, as well as the best practices. But do more than just the procedures and SOPs. Go visit your suppliers. See if they're actually following the right procedures that you implemented. Now let's talk about some specific examples. Now, small parts requirement. I think that's one of the easiest requirements to know. Basically, this requirement says that if it's a product for a child under 3, it cannot contain small parts before and after testing. This is an example of a product here that is intended for a child under 3, and it contains a small part. It's a toy chicken, and it has a toy egg, and the egg fits in our small parts cylinder. If you have a compliance program, it's important that you separate all those products that are intended for children under 3 so you can know what products, what regulations are subject to those products. Now, one of the problems could be that a lot of firms are not sure what products are for children under 3 versus what products are for children over 3. So be sure when you're age grading your products that you're matching the attributes of the product to the abilities of a child. Now here's a product that's for children under 3 and is subject to small parts. The first example I showed you had a small part as received. This particular product does not. However, it still requires small parts testing where you would do use and abuse testing. You would do an impact test here to see if any small parts liberate, but you would also do torque and tension to see if any of those components can be twisted or turned and liberate a small part. So having a compliance program will help you know which products are subject to the small parts requirements and how to conduct small parts testing. Now, this product, because it's a children's product, is also subject to other requirements. Lead, phthalates, ASTM, but not just one provision in ASTM. It's a battery-operated toy, but also it makes sounds. Track and label and certification. So again, it's important that you know your products and you know what requirements are applicable to your product. Now here's an example of a product that is very similar in category. There are building blocks in a container that's very similar, but the key differences here are the number of pieces in the product and the sizes. The one to the left is intended for a child under 3. Why? It has 29 pieces, a smaller number of pieces, as well as large size pieces. So that particular product is for children under 3. The one on your right, similar building pieces, but there's 102 pieces, and the blocks, the pieces are smaller. So that's important when you're doing your compliance program to understand that what products would be for a child under 3 versus a product for a child over 3, because the requirements are different. And let's look at, they're similar but different. Let's look at them. Lead, phthalates, small parts, tracking, label, and certification. Now let's see what the difference would be on the right. Lead content, phthalates, small parts cautionary statement, and tracking, label, and certification. The biggest difference here, if it's for children under 3, it cannot have a small part. But the one on the right, because it's for children over 3, it can have a small part, but it's required to have a cautionary statement. And we'll go over that in more detail in the next slide. We often see violations with the labeling requirements because I think firms just see other products out there with that small parts cautionary statement on there, and they just feel, oh, we better put a cautionary statement on our product too, and your product may not even have a small part. So it's very important that you understand when you use the cautionary statements. So the cautionary statement for small parts, that is only applicable if the product is for a child 3 years old, 4 years old, or 5 years old and have a small part. That's the only time you would need that cautionary statement. Another problem we see with balloons. A lot of firms think, okay, we'll put a cautionary statement about balloons if there's a toy in a game that has a balloon. But you also need the cautionary statement for balloons if it's a bag of balloons. Any latex balloon, regardless of your intended user, should have that cautionary statement on it for balloons. And then there's cautionary statements for balls and marbles as well. Now, this slide here is an example of a firm that had a lot of violations with labeling. This product here had a small part, and it was for children older than 3 plus. And this first cautionary statement here was before they instituted a compliance program. I mean, I can't even read the first label here. It says warning, and the fonts are small. You barely can see what it says, and it's not the appropriate cautionary statement. After they developed a compliance program, they created that warning there, and that is the appropriate warning. Another common problem we see is in our durable infant and toddler, with our infant and durable product category. What is a durable infant toddler product? It is defined as a durable product is intended for use that may be reasonably expected to be used by children under the age of 5 years of age. And here is a list of our durables, durable infant and toddler products. Now, here are some common problems we see with our durables. Ensuring that third-party testing laboratories are accepted, accredited, and they know the mandatory standards. A lot of times our durables, we find that they are tested, but they're not tested by an accredited, accepted laboratory. It's a children's product, so it must be tested by accepted, accredited laboratory. Another problem we see that if they do have an accepted accredited laboratory, they may not have the updated version of the standard or aware that the standard has been changed. So please know the regulations, and if you have a compliance program, you will be able to ensure that you are updated with the regulations. Another problem we see with durables, registration cards. You have to make sure registration cards are attached to your durable product and it's visible at the time of consumer purchasing it, and we'll go over that in a little bit. Another problem we see with durables are the labeling requirements. Sometimes firms are not sure, well, I have all the labeling information that's required for track and label. Is that enough? Or I have the labeling requirements for the registration card rule, but you need both. And I'll show you an example of that slide in a few. Example of a registration form. It comes in two sections. There's the section at the top the consumer keeps, and the section at the bottom that the consumer mails in. There's so many different components, parts of the registration form, so I want to go over it so you can make sure your products have the correct information. It always needs to have the purpose statement there at the top. Postage paid. We don't want consumers paying to send it back. We want an incentive for them to fill it out. So let there be a postage paid card for them to mail back in. The manufacturer's address, and if the manufacturer doesn't have a postage address, there should also be a website address listed. I'm not sure if everybody can see all the components here, and then the consumer needs a area there for the product information. So all of this information is in the regulation, and it's important that it's a part of your compliance program, that you know all the components of a registration card. The next problem that I spoke of about the labeling requirements. So because durables are a children's product, it's subject to the track and label requirements. As you can see in this diagram on the left, those are all of the required information that a durable product needs to have on the product and the packaging. On the right side is what's required under the registration labeling requirement. As you can see, some of the information overlaps, so a good rule of thumb is to make sure you know the information for both, and both the track and label requirements and the registration labeling requirements are on the product and the packaging. If you are importing a children's product, it's subject to lead requirements. The biggest thing to remember about lead is does your product have lead content or lead in paint or both? If you're developing a compliance program, know the difference of the two. Lead paint is basically surface coating. And surface coating, if you don't know what that is, can it be scraped off? And know that if it's lead in paint and has surface coating, the requirements are it cannot exceed 90 parts per million. But know the difference if it's lead in content. Lead content is 100 parts per million. And that's basically if the product doesn't have surface coating, but the lead is baked in the product. So you need to know the difference if your product has surface coating or not, and some products may have both. So develop a compliance program where you know the difference, and then also know what the exemptions are as well. We commonly see problems under our Poison Prevention Packaging Act, and mainly as it relates to the regulated substances. The key to remember here is that there are 32 substances that require special packaging. If you're developing a compliance program, know what those 32 regulated substances are and know which ones require which special packaging. So, in ending, know your products, know the regulations, test your products. If you do those things, that will help you develop a great compliance program. And if you have any questions about what the regulations are, you need help interpreting the regulations, we are here to help you in the Office of Compliance. And you can always use our famous regulatory robot to help you through the process as well. Thank you.
Thank you, everyone who spoke on panel 1. We're going to be beginning panel 2 shortly here. While they're getting settled, I'm going to introduce our second panel of speakers. The presenters for our next panel include representatives from manufacturers and retailers. We have with us today Jay Howell. Jay is the Senior Director, Product Safety and Compliance Monitoring, Research and Risk Management at Walmart. Prior to joining Walmart, Jay was a former Deputy Executive Director and the Acting Director of Compliance here at CPSC, and previously served as the Vice President of Manufacturing and Operations at Cooper Industries. Next to speak will be Lisa Pankowitz. Lisa is the Vice President of Global Stewardship for the Clorox Company. She is responsible for regulatory, technical, and scientific activities encompassing global regulatory affairs, product safety, chemical management, and global trade compliance. Lisa has over 30 years of industry experience across multiple regulatory sectors. Next will be Jackie Pollock. Jackie is the Quality Assurance Manager at the Manhattan Toy Company. She has over 25 years of experience working in product development for consumer packaged goods, including time with Aveda, Gartner Studios, and General Mills. Finally, Rebecca Sharp will speak. Rebecca is the Senior Manager of Product Safety and Compliance for Best Buy. She is Best Buy's expert on product recalls, product compliance, process development, and recall execution. She has led the development and continuous improvements of a recall process at Best Buy that provides automated communications, system controls, and central oversight for consistent execution. We've asked all of our panelists to give a brief overview of their firm's compliance program and then provide information related to 4 questions: how their firm sees technology changing their compliance programs going forward, how their firm ensures that third-party logistic providers and other third parties and supply chain partners are integrated into their compliance program, how their firm integrates safety, quality, and consumer care programs to ensure that information is shared among all divisions, and any sort of audits, stress tests, or other checks their firm employs to ensure their compliance programs work effectively and as intended. With that, I'd like to welcome Jay Howell to start the panel off.
Thank you. Do you have the clicker?
I ran away with the clicker. Sorry about that.
All right. Good morning, everyone. So now that we've heard how you're supposed to set up a compliance program, now I'm going to show you kind of how Walmart has set up a compliance program, and hopefully there's a match there somewhere along the way. So within Walmart, as you look at kind of a perspective on a compliance program, right? There's 4 key elements that make up the foundation of what we at Walmart believe to be an effective compliance program. And the first one is the culture, right? Is the tone at the top one that is supportive of the compliance effort, right? The executive management team has to be strong, they have to be visible, and they have to be very explicit in communicating that support for an effective compliance program. And along with that, they've got to ensure that the compliance effort has the resources and the funding and the stature within the organization so that they can be effective in carrying out this compliance program. Governance is a key point, right? Are the company's policies and procedures, are they in writing? Can they be accessed easily? Can they be understood? And as you heard in the first panel, are they reviewed and updated on a regular basis, right? Are they current? Education and training is another fundamental within a good compliance program. You've got to communicate your protocols, your procedures throughout your supply chain, including your third parties. You've got to be very explicit. You need to tell people what to do, why they're doing it, and then where to go to if they have questions or concerns, right? So you got to make sure you get that word out. And then finally, there's the accountability piece, right? Does the company consistently and fairly reward good behavior, correct bad behavior, and hold all parties accountable, right? The accountability piece is certainly very important in the program. So the program fundamentals at Walmart. As I just talked about, it starts out with good and effective leadership, actively supporting a good compliance program and making sure that everyone in the organization understands their role and their commitment to compliance. Then there's the risk assessment piece. And we at Walmart use risk assessment to make sure that we are appropriately allocating our resources, making sure that the resources are allocated properly to those elements that present the highest risk within our compliance program, and then work our way down the list. Standards and controls. Once we determine where the risks are, do we have standards and do we have controls to mitigate those risks? And then awareness. How do we ensure that all the appropriate parties are made aware of the relevant findings? Everybody's got a role to play in this compliance effort. You need to make sure they have the information they need to execute as intended. That also goes along with the training piece. And then finally, the monitoring and response. How do you know that you have a reasonable and effective compliance program? You put it in place, you think it's good, but how do you know, right? You may not have any reason to believe that your program is not compliant, but you actually have evidence that your program is compliant. You need to go back and check. You need to take the pulse of your compliance programs on a regular basis to make sure that they are effective and performing as you intended them to perform. So within the product safety compliance team at Walmart, we start out with the regulatory change management team. And that's a team of people that review laws, rules, and regulations at local, state, and federal level, right? Those of us in both manufacturing and the retail side of consumer goods know that it's much more than CPSC that we have to deal with, right? There is local regulations, there's state regulations, there's federal regulations, not only from CPSC, but if you're on the retail side of the house, you're dealing with NHTSA, you're dealing with EPA, you're dealing with FDA, you're dealing with FTC. I mean, there's a lot of regulatory responsibilities that you have. So we start out with regulatory change management. So this team monitors for proposed and enacted legislation. As those rules move through the relative houses and get enacted, they then pass them along to subject matter experts that assess the potential impact that those laws may have on our business. And if there is deemed to be a potential impact, then there is an action plan that's developed and then executed to ensure that we are going to be compliant and mitigate any risk associated with that statute. And a lot of that's done through the standards and verification team, right? So as we determine what the new regulatory requirement might be, we develop the appropriate standards, and then we put programs in place to verify that our suppliers and our stores are compliant with the new requirements. If, however, we find that there's an issue, we have a product removals and recall team. Now, anytime that the standards and verification team deems that they have found a product that is non-compliant and perhaps is subject to a recall, after we fulfill our reporting requirements to CPSC, the product removals and recall teams manages that whole reverse logistics piece of the equation. So they're responsible for identifying the actions that need to be taken. They work with the supplier to ensure that we're in agreement on the appropriate disposition. They communicate with all the appropriate resources within Walmart to put the register blocks in place, to freeze slots within our distribution centers to make sure that we halt the movement of any product so we can eliminate that in-transit piece of the equation. And then we communicate with our return centers to ensure that we can control that product as it moves back through the stores, through these return centers, to that final disposition, whether that be returned to supplier or to destroy or dispose. And then we have our regulatory reporting piece, right? We have dedicated resources to regulatory reporting. As you can imagine, Walmart has no shortage of data coming in from all of our various resources. And we spend a good deal of time analyzing that data. But as we've all heard over the last decade, from Gib Mullen and Mark Schoem, when in doubt, report, right? There is no penalty for over-reporting, and not every report necessarily results in a recall. But if you fail to report, you potentially have a problem, right? So that doesn't mean you do the data dump, right? I'm the guy that's known for accusing retailers of dumping data on CPSC. So you don't get to just pass your data through. There is an element of analysis that you're required to do. You need to do that to understand what's going on within your business. But when you have that reporting obligation, as I said, when in doubt, report. It is the most prudent thing that you can do. And then we have our program monitoring effort. And so this is internal to the product safety and compliance team at Walmart. And what this individual does, they are separate from program development and execution, but they come in essence, provide oversight to our compliance programs. So they will go into a program, they will look at documented procedures and processes. They will ensure that the team members at Walmart are executing to those procedures and processes. They will evaluate data to ensure that the program is working as intended. They identify any gaps. And if there are gaps or weaknesses within the program, we go through that plan, do, check, act feedback loop to ensure that as we do our monitoring effort and find opportunities to improve the programs, we're constantly feeding that back through the team. So, once again, if you're not constantly taking a look to see if your program is delivering the results that you intend it to, you may be assuming something that's not true, right? You need to check and make sure your program is delivering. As we work with our supply chain, and this is not only our suppliers, but with the laboratory partners that we have. We actually have, half a dozen laboratories that we work very closely with. And some of the tools we use, everything from specific product requirements, product performance requirements, and these are not only necessarily voluntary standards or mandatory standards, but they could be internal Walmart standards, for product performance standards that we have in place. But we also have product safety and compliance directives, where as we implement programs, we communicate this back out to our appropriate suppliers and labs to make sure they understand. To our merchants and to our buyers, replenishment teams within Walmart, we generate toolboxes where, if we are able to develop a tool that provides them relevant information that helps them in the product development and supplier management side of their business, we'll communicate through what we call a toolbox and deliver that tool back out to our merchants and replenishment teams so that they become aware of these tools, and along with that we provide training. Our fundamental is the Q's. Follow the Q's for supplier product safety and compliance. C is for comply. The U is for understand. Then educate and support, right? And those are the fundamentals of that Q program. From a product verification standpoint, we've got a pretty robust system. We use a third party to go out and match our open POs with test reports. Test report has to be no more than 1 year old, And so as that purchase order is cut, there's a match to a test report. And when the match is made, then there's the look for the product certification that goes along with that, right? If there is no match made, then there's follow-up. Typically it tends to be that there's a missing test report to go with the purchase order. So then there is communications with the suppliers and the labs to understand where that test report is. Has a test been conducted? If not, then you'll match up the supplier to a laboratory and get the testing done to make sure that you got that match on those products. So, the compliance effort, in essence, is pretty simple. It's identifying what are your risks, what are your obligations, mitigate those risks, comply with your obligations, and then monitor over and over again to make sure that you are compliant. In short, find your problems and fix your problems. Mm-hmm. All right? That's all. Thank you very much.
Thank you. So good morning, everyone. As previously stated, I'm from the Clorox company, and I'm responsible for what we call global product compliance, which encompasses our regulatory safety, a little bit of environmental compliance, and our trade compliance. Clorox is located in, I'm sorry. Clorox is located in Oakland, California. We're a company a little bit over 100 years old. We started as a chemical manufacturer in 1913, and since then have developed into a consumer product and a professional product manufacturer of over 20 brands. You see some of them here listed here. I think most folks know us from our cleaning division, but our cleaning division comprises only about a third of our product portfolio. Most know us from our standard, what we call our mother bleach product, which is our standard bleach product. But we also have a wide variety of product categories in both household, lifestyle, and a small percentage of our sales go through our international division. We have product categories that span from charcoal, Kingsford charcoal, Glad, Fresh Step, cat litter. We have Burt's Bees Cosmetics. We have Brita water systems. So as you can see, we go from bleach all the way to lipstick, and we're regulated in each one of these categories. Different regulations, different reporting requirements, different agencies, but all have one thing in common, that is our commitment to safety. And our commitment to safety can't change depending on these product categories. It's one commitment to safety. If you went to our product website or to our company website, you'd see that commitment to safety. Our first core value is do the right thing. And we live by that value. We walk that talk, and it's something that we're very proud of. When it comes to who in our product, our safety compliance program, our safety compliance program is managed by three core functions: quality, legal, and global stewardship. And those three core functions, we're not the only core functions that are responsible for safety within the company, but we are the face of safety for the company. And that is, we comprise the corporate governance program for the brands that we represent. It's really important that folks within the organization understand and see that. We bring in other departments as necessary, so R&D will come into the scope. Our consumer affairs will manage our intake and our escalation process, but these three core functions really represent our corporate governance. When we think about the infrastructure, our how do we manage our compliance program? Our compliance program starts first and foremost with the foundation of our notification and our escalation process. Our notification and escalation can happen anywhere within the company. It can start at any of our business functions. It could start at any any level, any business function, any person within the organization can raise and escalate an issue. Those issues are then, if it requires cross functional elevation, those issues then go into what we call our product regulatory compliance team. This team is comprised of representatives, senior representatives from legal, quality, and regulatory. And those three functions will then look at the issue and then bring that and escalate anything that needs to be escalated to our core, what we call our corporate governance team. Our corporate governance team is managed by our executive committee. So as you can see, we can start at any function within the company, and we could raise that function, we could raise that and escalate that process throughout the company. Three main processes. Now, we have a lot of processes that manage our compliance program. Three main processes that we use to identify, to notify, to manage, and to correct our potential compliance problems potential compliance risks our intake and our escalation process, our product issue team, which I'll explain in a minute, what we call our PIT team, and our recall process. Our consumer affairs team is responsible for our intake and our escalation process. Our intake and escalation process is our way to receive information, to report that information, to track that information, and then to manage and to report that information out. That information then is our central location. It's a central database that is able to take all of this information from different areas and keep it in one central location. Issues that need to be escalated or to be elevated, to be looked at throughout the company are then analyzed by what we call a PIT team. A PIT team is a project team. It's made up of core cross-functional members that are able to identify any potential issues. They identify, they quantify the issue, and then they remediate any potential concerns. This PIT team then will decide, will based on the information, they're fact gathering, and based on that information, will then make a determination whether or not it's a CAPA or whether or not we need to go into a recall process. And obviously our recall process, very robust process, which is used to identify, quantify, and remove any product or supply from the market. When we look at compliance and our compliance program and the role that technology is playing in our compliance program, it's really important for us to understand, as I just mentioned, the role of technology today. It's imperative that we have the ability to integrate multiple systems. We receive information from a variety of different systems. Social media, we receive information from our consumers, from our employees, from our suppliers, and it's really important that we're able to get all of that information into a system. We're able to monitor and track that information. We're able to analyze that information. I think the way that technology is playing a role today for us to identify trends, to proactively stay ahead of potential issues. Even today with some of the software and the advanced tools that we could use to monitor and to be able to use some trigger words as we receive complaints and as we receive information from our suppliers, to be able to take those tools and then be able to integrate those into our compliance program. When we look at third-party integration, this also plays a very key role in our compliance program. We use third parties for a good deal of what we do, being the size that we are. We use third parties to manage our recall processes. We use third parties to manage our intake and our consumer complaint processes. We use third parties, obviously, to manufacture, as our suppliers. So it's really important for us to understand and to have our partners understand their role and our role within the organization. It's important, obviously, for obvious reason, to have supply contracts and quality agreements. But those supply contracts and quality agreements aren't only in place for the obvious. They're also in place so that we understand our role and our suppliers understand their role. Clarity of these roles and responsibilities is very important so that when we're in the middle of an issue, we're not each looking at each other as to understanding what that role and responsibility would be. Change control is also another important aspect when you think about third parties. If we have a supplier, that supplier is producing a material for us, or a bottle or a cap, they change something in their process. They change a mold, they change a color, they change a plastic. All could have a tremendous impact on our products and the safety and the regulatory compliance of these products. So it's really important that they understand our change control processes, we understand their change control processes, and that we have a shared communication. That shared communication, much easier said than done. It's a lot of hard work. It's us going there and auditing them. Last week we had a retailer. Last week we had a retailer at one of our facilities auditing us. So it's a shared communication and a shared process between us and our third parties. It's also important that they're integrated into our quality systems and our processes. It's one thing for us to have really great SOPs and to have great quality systems, but if we don't share those with our third parties, they're probably not going to be understanding the significance of what we're trying to do within our own four walls. Last but certainly not least, we have a very, very robust supplier performance program. So we manage our suppliers, ensure that we have continuous improvement with our suppliers, and ensure that we have corrective action if we have an issue that we need to manage in a more serious way. Finally, our audit and our quality checks. One way that we're able to ensure that we have an efficient compliance program is our robust end-to-end audit processes. We not only do internal audits, we audit our raw material, our packaging suppliers, our co-packers, our manufacturers, our third-party service providers. As I mentioned before, we do mock recalls, we do mock consumer complaint and intake calls just to continuously check and test our processes. Our product performance and quality monitoring systems, it's our way to ensure that we're continuously looking, understanding our trends, understanding how to mitigate anything that could be a potential situation in the future. And finally, our customer integration and how we integrate our customer care program within and to ensure that it's shared at all divisions. Very easy for us to take that data in, to keep that data, to share it with R&D, but it's more important that we're able to share that throughout the company, throughout the business functions, so all the business functions understand any potential compliance risk. We have a centralized data system. It's able to manage and analyze all of our information from various sources. As I said before, we get information from a wide variety of sources, and it's really important for us to be able to understand what's coming in, to be able to record it in a way where we understand and are able to manage anything that could be a potential issue. Then we have a comprehensive metrics that are focused specifically on tracking and trending data, whether it's information that's coming in from our adverse event program, it could be coming in from our consumer program, it could be coming in from our suppliers, it could be coming in from our agencies, our regulated agencies. But it's really important that we're able to go through and we're able to analyze and understand what that data is telling us, because again, the information is there, and it's just how we're able to track and understand and utilize the information. The information then is shared appropriately within our functions. And again, it's not because we want to to say that there's R&D developed a product that's not meeting a consumer's need, but R&D may have developed a product that needs an adjustment. It may have developed a product that may need to change. And it's really important for us to understand that as we go through our processes. Again, I think I explained we have an escalation and a notification process, so that information is shared within the company. We speak with one technical voice, and it's continuous improvement. So it's a continuous evolving process that we manage. This information, I think it's also important to understand, this information is shared not only within the business functions, but then it's also escalated into what we call our BOLT team, which is our business operations leadership team. So we take these trends, we take these the analysis of this data, and then we report that into our executive committee. So it does start with our business functions, goes into our corporate compliance, and then it goes right into our executive committee. Thank you.
Which button am I pressing? Good morning. I'm Jackie Pollock, and I'm the Quality Assurance Manager at the Manhattan Toy Company. And I thought I would start by giving you a little bit of background on our company. We were founded in 1978, and for a little piece of trivia, by the grandson of Samuel Goldwyn of Metro-Goldwyn-Mayer, the Hollywood mogul. Francis Goldwyn is the grandson who founded Manhattan Toy. They were in New York City, so thus the name. Eventually, he sold the business and moved to Minneapolis, Minnesota, which is where we are headquartered now. I wanted to give you a little perspective on the size of our company, which is quite a bit different from, of course, Walmart or Clorox or Best Buy. We have 28 employees at our headquarters, and then another 15 employees at our warehouse, and then 3 at our European sales office. So we are a very small company. We have approximately 500 SKUs in our product offering. We sell to the specialty boutique market, so small independent toy stores. But then we also work with larger national retailers like Target, Barnes & Noble, Amazon, a couple of UK retailers, Harrods and John Lewis. We have several of our own branded lines, Groovy Girls, Baby Stella, but we also do a little bit of licensing with Dr. Seuss, Wimmer Ferguson, and we've actually just are in the process of, we're working on a license with Lego. So that gives you a little bit of background about our company and the size of it. And then the other thing I wanted to point out is that all of our products are compliant for sale in the United States, Canada, and Europe. And as you can imagine, toys are very heavily regulated, so we have to be compliant with the rules in all of those countries. So a little just quick overview of our compliance program. It starts with our design. We include our factories, our safety testing, inspections, CTPAT, which is our logistics for transportation, and then association memberships. So the first part of our program really begins with our design team. We try to make sure that all of our product designers are very knowledgeable themselves about compliance for toys and toy safety. So they're all very aware of different safety requirements. They have an understanding of what is appropriate to different age grades. Earlier you heard discussion about whether toys were for over or under the age of 3. It's a very important distinction. So we make sure that our design team understands these things as they're designing new toys. And then also we have QA oversight. So the quality assurance manager, which is me, attends all of the product development meetings. So I am meeting with the designers and throughout the process. And we're constantly reviewing things for safety as it's being designed. In our office, we have the little choke tube testing and the rattle gauge and pull test equipment and different things that we can kind of keep assessing as we're designing the product, so that hopefully, right off the bat, it's designed in a way that will be compliant. The next thing is our factory partners. We have worked very carefully to cultivate a portfolio of factories that we work with. All of our factories specialize in toy manufacturing, and so our factories are already very knowledgeable themselves about toy safety requirements. They have in-depth understanding of toy safety regulations, for products throughout the world because they manufacture for companies all over. We've also tried to really maintain long-term relationships with our factories. We've really tried to build partnerships. We collaborate with them for mutual success. Our factories, they know our product, they know our standards and our quality requirements, our design aesthetic, things like that. But because we're loyal to our factories, they're loyal to us, we have mutually beneficial arrangement. It's in their best interest to make sure that the toys are compliant and will pass all of the safety and regulatory requirements. We also make very regular visits to all of our factories, so we know what's happening within their factory environment and how they operate and what their safety protocols are. And then we require all of our factories to be ICTI certified or have some other ethical audit. This is a program that audits factories to make sure that they are compliant with the social regulations within their countries. The next part of our program is safety testing. Now here again, we have a strategic partnership, I would say, with UL, which is under a Writer Laboratory, who does all of our safety testing. Because we're a small company, we don't have teams of people in compliance departments. It's just me. And so UL is our compliance team. So we rely on them for not only our safety testing, but for helping us understand which regulations might apply to different products, helping us understand age grading if we have a question about that, maybe evaluating different kinds of materials. And so we have a contractual arrangement with UL. So we work exclusively with them for all of our safety testing. And then it also gives us the ability to call on them as, sort of our compliance and regulatory team. And so that has been a really beneficial partnership for us to work exclusively with them. And then our inspection strategy. So before it ships, all of our product is inspected. And so we maintain a China-based team that conducts all of our final random inspections. The advantage that we feel about that is that we've got people who are dedicated to our product. They only work for us and inspect our product. Again, we have a long-term relationship with them, so we know that they're very well acquainted with our product and what our quality and safety requirements are, and they feel a sense of pride in making sure that the product that is ready to be shipped out is compliant. When our team is overloaded, then we will occasionally bring in an outside inspection service, and then typically it is UL, again, because we have a relationship with them, we trust them, and so we'll call on them occasionally, but for the most part, we try to stick with our own dedicated team. We have had challenges in the past where we've been required to use other inspection services, maybe by a retailer that we are producing for, and had challenges with other inspection services not being completely honest about how they were conducting the inspection. So it is a very important piece of the whole process. And then we adhere to the American National Standards Institute in using tables for determining what the acceptable quality limits are in product inspections. And so that is an industry standard. And then we are CTPAT certified. This is the Customs Trade Partnership Against Terrorism. It's part of the U.S. Customs and Borders Patrol. We're a member, we're certified, and so this verifies that we have processes and procedures in place to verify that we have a secure supply chain. We're required to meet different minimum requirements, and we have to review our supply chain, annually to make sure that they are compliant. And then the final piece really is association memberships. We are members of the Toy Association, the British Toy Association, some of these other organizations that for us, again, being a very small company, these are resources for us to draw on. So, if we are confused about maybe a rule or how to be compliant for something, we can call on any one of these different organizations who will help us to understand regulations and help give us some direction on how to manage different issues or different products or issues that might come up. So for us, this has been very important. And then just regarding a couple of the additional talking points they had asked us to discuss, technology for us is making our reverse logistics much easier. We've been able to implement new systems that help us track exactly where all of our product is sent, by lot code, who it was shipped to. So if and when we have to do a recall, it's easier for us to know exactly where those products are. But one of the challenges that technology has brought for us is when it comes to counterfeit product. It's become very easy now for people who are counterfeiting product to go online and sell that product. There are websites out there, particularly in the Asian market, where you can go out and do a search for a product by name, brand name even, and it will give you all kinds of different people who will manufacture that product for you. And so then you can go and get that product manufactured and then go online and sell it. So that has been very challenging for us because we do occasionally find our product counterfeited on the market, and then it's damaging for our brand and our reputation if those items are not safe. And then as far as checks, audits, stress tests go, it's really through this process that I talked about. It's making sure that our product pass safety testing first and foremost, and then does it pass our inspections, and then we just monitor all the time any kinds of comments that we receive from consumers or from retailers about our product. I think that's about all I've got for you.
Good morning. Once again, I'm Rebecca Sharp from Best Buy. So at Best Buy, product safety and compliance is important at all levels of leadership, and our tone at the top demands visibility of the risks and accountability of our team. We provide quarterly reports on key issues and activities to the Audit Committee of the Board of Directors, and our policies, procedures, and compliance activities are discussed weekly at our Product Compliance Governance team. And if there are issues that we need to run by leadership for review or visibility, that's escalated up to our Corporate Compliance Committee run by the Chief Risk and Compliance Officer. So that's just our basic structure there. So when it comes to customer product incident reporting, it can come to us in a number of different ways. People could walk into our stores, give us a call, post a review online, post something to social media. So what we do is we filter all these down, all these different communication channels into a case management system. And the way we do this is we have our customer service agents answer yes or no when they're doing the intake to the question of whether or not the incident could pose a potential product safety concern. If it's a yes, it is then emailed to another team who creates a case in this system. And the agents have been trained, so if they have any doubts, is this product safety, is it not, we say err on the side of caution and just make it yes. Now, we do also edit the no's that we get. We bump them up against a text analytics system to look for any keywords that could have safety concerns, such as heat or smoke, that type of thing. And if we do find anything that's missed, we take it back to that particular agent who created the case and do further training. And at this point, cases are rarely misidentified. So we review potential safety incidents daily and take actions that are necessary, immediately escalating anything with property damage or serious injury. Our other cases are reviewed each week by a team that consists of product safety members, legal, claims, customer care, and any other departments as necessary. All potential safety concerns are reported to the vendor, and then they're further triaged to see, do we need to report them to the CPSC? Is a recall or other correction active warranted? And the team that conducts these reviews are very well versed in product safety, and they work in an abundance of caution to keep our customers safe. Now, that said, this is an exercise in judgment, and there's room for disagreement about the appropriate actions to take based on the information. And there's no perfect system or one-size-fits-all for every company, regardless of the number of incidents they get or the type of product. But we feel that we've really developed a system that works well for Best Buy. So product recalls. When it comes to product recalls, over half of the time we find out about them by proactively checking the CPSC website because the vendors do not give us advanced warning. Because of this, we've really engineered our response to, we have to shut everything down the same day. So we just expect that anytime anything's announced. Once the recalls are entered into the system, once we get the information from either the CPSC website or hopefully the vendor, they're entered into our recall business management process system. It's a lot of words there, but it serves as a single point of entry for all the relevant information. And then that in turn sends automated emails to over 20 different teams around the company with their specific tasks they have to do and instructions on how to do them. So even if somebody's new, they know how to do it. They also have time limits. So what we consider a reasonable time to shut these things down or do their process, and if it exceeds that time limit, an email is automatically generated to the product safety team for follow-up and to see how we can support and get that done. Our task management system, we have a different one at the retail stores that lets them know that they have to remove all the products from the shelf the same day and quarantine them in the back off the sales floor. Now, once that's done, transfers are then automatically generated every day at every store with any recalled inventory until all the product is gone. So nobody has to enter that every day. And that's especially helpful with returns. Because again, if a store clears out all their inventory, and then I come back with my computer a week later and I have it, well, now they have inventory on the shelf. So two things happen. Once the recalled inventory is processed at the returns counter, a sticker prints out with a red stripe on it, and it says recall on it. And it also says where they should return it, the appropriate place. And also that automatic transfer starts up again. So the next day they'll get a transfer order. And that doesn't matter if it's 5 years from the recall. That transfer is always ready to be activated as soon as our system indicates that there's inventory at the store. So that gets back to our warehouses, and that's even if it's going to be destroyed. We don't want the stores trying to handle destruction. So we consolidate at the warehouses, and then they take appropriate actions from there. Let's see. There we go. We do have integrated system blocks, so this recall system I described, that's a single point of entry. It feeds into our product information system, and that blocks or shuts down all the UPCs permanently as appropriate. And if the vendor wants to bring in a corrected product, we require new UPCs and new SKUs because we don't want that cross-contamination. And that's really the only way that we feel confident that that's going to happen. That in turn connects with other systems to block sales, and not just at our main stores, but also our secondary markets channels, our business-to-business, our specialty retailer. And as was mentioned earlier, when somebody does the pop-up, Well, he said, let's say it's the same day. The recall happens at 10 o'clock in the morning. They're working to get the products off the shelf, but at 10:30, somebody picks up that product, goes to the store, goes to the register, tries to buy it. There is a pop-up that says, recalled product, do not sell. So it's not just, this is a problem or you can't sell it, because we don't want anybody to go around that notification. Other things that it blocks, we've already talked about removing it from the shelf and quarantining the products. It also cancels any open orders in flight that have not yet reached the customer. In-flight service orders. So again, if I've brought my computer to the Geek Squad in our store to be repaired and they're working on it, they're in process, the service agents will get a notification on their systems that says, hey, the product you're working on has been recalled. Click here for further actions. So we don't miss anything that's already in the customer's hands. We're not going to see it as a sale, but we're working on it. Also removes the product online, so it's no longer available there, and posts a notification on our dedicated recall page on our website so customers can click on it for further information. So third-party partnerships, we work with third-party labs for product development, later on product testing, any forensic analysis needs that we have. In the event of a recall, we would expect our vendors and suppliers to handle that process themselves. And they may choose to work with a third party as far as having customer call centers or customer outreach, handling refunds or return requests or whatever the corrective action plan is. Storage and destruction is also a major factor. Hopefully that is being stored in a separate place, quarantined from the other product. Now, if Best Buy ourselves, if we had a recall, we would look to working with a third party for any needs that we had for those services. So our compliance team consists of engineers with years of experience in product design, development, and manufacturing. So that allows us to provide guidance to our internal buyers so they can identify any potential concerns or the risk of product safety and compliance before it arises. Some of the things we support them on are new product types, emerging technologies, children's and healthcare products, rideables, and other things that contain lithium-ion batteries. But we're there to support them. So if they have questions, please come talk to us. We certainly have a monitoring and continuous improvement program. Our product incident reports are analyzed monthly, quarterly, and annually to look for any trends and take action if necessary. Recall validation is run to confirm that the point of sales block is in effect at all of our retail locations, and that happens the same day the recall occurs. So we block it and then we check to make sure it's blocked. The recall system also keeps track that all the required tasks are completed, and it gives us reporting on time to completion metrics so we can evaluate our response and make any improvements as necessary. Recall training is required for all of our frontline employees every year, and we take a look at the training every year and make updates as appropriate. And we also have hourly automated system checks to confirm that everything we shut down, it detects and self-corrects any unintended changes to recall product attributes. Another thing I thought of, but I hadn't put on here because I just thought of it this morning, we also run inventory reports on recall products up to twice a week. So we're checking to make sure that is moving out. And then finally, we are committed to continuous improvement, and we don't see our systems as static. So if we see room for improvement or efficiencies, we take action. Thank you.
Thank you, everyone who presented on our second panel. Welcome our third panel up to the stage. Presenters for our third panel include representatives from industry trade groups. Our presenters are, first, Autumn Moore. Autumn is the Director of Regulatory Affairs and Compliance for the Retail Industry Leaders Association. She is responsible for leading and facilitating activities for RELA's Consumer Product Committee, comprised of retail regulatory compliance and quality assurance executives, as well as in-house counsel. Next, we have Jennifer Cleary. Jennifer is the Vice President of Regulatory Affairs at the Association of Home Appliance Manufacturers. She works on a variety of regulatory issues and interfaces with federal agencies, including the Department of Energy, the Environmental Protection Agency, and the Consumer Product Safety Commission. Kelly Mariotti is the Executive Director of the Juvenile Products Manufacturer Association. She oversees JPMA's pragmatic, regulatory, and legislative and public affairs activities, as well as their certificate program engagement in the ASTM standard setting process. Finally, but not least, we have Kristen Kern. She leads the American Association of Footwear Apparel's sustainability portfolio, working with governmental and industry to further environmental sustainability in the apparel and footwear industry. She also leads the AAFA's product safety portfolio. With that, I'll turn things over to Autumn to finish off our third panel. Thank you, everyone.
Appreciate the opportunity to testify today as a part of this panel with my fellow trade association colleagues. By way of background, RELA's members include the largest and most innovative retailers, and the retail industry employs over 42 million Americans and accounts for $1.5 trillion in annual sales. RELA members strive to provide American consumers with a wide variety of safe and innovative products, and at RELA, our primary mission is trifold: educate, advocate, and collaborate. Trade associations in general serve a variety of functions. One key function is to disseminate information to educate members on the impact of legislation and regulation to their business. Trade associations also serve a key role in advocating to enact changes on behalf of our members to propose laws or rules. Also, by joining coalitions with like-minded goals, our reach is further extended, and we can use that extra leverage to speak with a louder and even stronger voice. One thing RELA does not do is provide legal advice. We can point members in the right direction to get that, but RELA does not serve that function. At RELA, I manage our Consumer Products Committee, which is a group of over 220 in-house consumer product quality professionals, compliance-focused professionals, and legal counsels. RELA offers a variety of ways that we disseminate information to the committee, including in-person meetings twice a year, often with CPSC officials participating, monthly phone calls, and timely email updates with information of importance. On each monthly call, half of the time is dedicated to an educational opportunity on a variety of topics. Past educational components have included an outside law firm updating on new Proposition 65 requirements in California, UL introducing members to their new furniture stability validation program, and even an update and partnership with JPMA for Baby Safety Month. Because RELA members sell all manner of products, the educational offerings provided to the committee are vast. Another major benefit of RELA membership is the opportunity to benchmark procedures and programs with their peers. RELA facilitates the benchmarking and provides members a safe space to converse freely with their colleagues. RELA is very mindful of antitrust concerns, and as such, we tightly monitor conversations and preview benchmarking surveys before they are sent to members to help ensure no antitrust violations occur. This seminar today is focused on compliance and compliance plans. Compliance is of paramount importance to retailers. Assuring all products sold on store shelves are safe is but one of many compliance activities retailers are focused on. In fact, retail compliance efforts also include food compliance at FDA, worker safety compliance at OSHA, environmental compliance including hazardous waste disposal at EPA, as well as human resource, pharmacy, marketing, labor, tax, foreign corrupt Corrupt Practices Act and Americans with Disabilities Act compliance, to just name a few. Additionally, states can and do have their own and often differing requirements for each of these areas. Then to add even another layer of complexity, locality requirements for each of these may also vary. On top of that, retailers are challenged with operating multiple locations, high employee turnover, and varying education levels of employees. Training employees in a meaningful, succinct, and effective way to remain in compliance is a continued challenge for retailers. Effective compliance programs must take an integrated approach to a company's ethics, values, and culture in the context of complying with legal and regulatory requirements. Finding the right balance between these two is a constant struggle. Retailers are unique in reverse logistics. They often are the key point of contact to the purchasing customer for questions surrounding a recall, and very often the facilitator of product recalls on behalf of the manufacturer. As the face of a recall to a consumer, and with brand reputation at risk, retailers are invested in ensuring product recalls are handled efficiently and effectively, even though they may not be the manufacturers of these products. Once a recall has been announced, many retailers have integrated software that stops the sale of those products, even if they have not been physically removed from store shelves. However, one issue that has been raised by RELA members is the lack of transparency about when recalls will be made public. Often our members are not made aware of a recall until they receive a CPSC press release or until they have heard about it on the evening news. This causes retailers to be caught flat-footed and at a disadvantage in administering the recall. Having lead time to assure that recalled products are removed from the store would greatly reduce the likelihood that they could be inadvertently sold after a recall is announced. This extra lead time of at least 48 hours will also mitigate a retailer's risk of unintentionally and illegally selling a recalled product. Another helpful measure would be to include not only the model and serial numbers for products recalled, but also list the UPC on each recall notice. It is important to note that UPC codes are different from SKU numbers. UPCs are universal, and having these codes listed on the recall press release would ensure that each retailer is pulling the appropriate products from shelves. SKU numbers are unique to each retailer for inventory purposes and would not translate into a usable system for all retailers. CPSC and Health Canada, along with Profeco in Mexico, have done a great job in joining together to conduct recalls where the same products were sold in each country. RELA asks that the agency extend the joint announcement effort to other U.S. government agencies where there is shared jurisdiction. If a car seat is recalled, for example, doing a joint notice with NHTSA would be helpful. The same goes for lithium-ion batteries where the Department of Transportation has issued warnings. Organizations can be siloed, and information from one department of a company may not make its way to a different department, so having information be posted from several sources could have a better chance of reaching the appropriate person within an organization. On many prior occasions, RELA has advocated to have the language removed from the recall handbook that essentially mandates the use of posters to announce recalls. We recognize that having in-store posters for recalls could potentially be helpful in certain circumstances if the retailer has the space and capacity to post them. However, customers, especially the ones who may have purchased the recalled products, would likely never notice the recall poster. Effective compliance programs very rarely include the use of posters to announce recalls inside retail stores, and therefore we urge CPSC to remove this de facto requirement. As compliance roles become broader in scope and even more important to an organization's culture and brand, we are beginning to see increased compliance functions at the C-suite level. A research report just issued by RELA and Deloitte on compliance functions within a company in general shows that 41% of those surveyed say that senior management of the company appreciates and embraces stronger compliance, and that 46% say that compliance function is viewed as a partner to the business as a whole. 14% of those surveyed say that their company actually has a chief compliance officer, and 36% expect their total compliance budgets to increase in the next year. We are encouraged by these numbers and are optimistic that retailers will only increase their focus on compliance efforts in business or operations. Compliance roles are becoming more high profile, and RELA stands ready to continue to provide opportunities for members to learn how to improve upon their existing programs. Thank you for the opportunity to speak today, and I anticipate your questions.
Good morning, I'm Jen Cleary with the Association of Home Appliance Manufacturers, or AHAM. We represent manufacturers of major portable and floor care appliances, so everything from your washer, your refrigerator, to your hair dryer and your vacuum cleaner, and also suppliers to the industry. We have about 150 members, and for those members we're providing technical services, standards development, and advocacy. So, AHAM doesn't really have specific policies and procedures that we're recommending to our members on how to develop a compliance plan. There are lots of resources for this, many of which I think the CPSC staff discussed this morning, and that's where we're really directing our members so that they can make the decision that's best for them. But that said, our members' top priority really is to make appliances that are as safe as they are useful. And so this is something that's top of mind for all of our members. It really starts with recognizing that risk assessment and product design, that's really where the process starts. So looking at, what risks could be associated with the product and making sure to design those out of the product. And then testing is also key to make sure that products are meeting or exceeding safety standards and continually working to improve those standards. And that's actually a key service that AHAM has been providing, particularly for the last 6 or so years. Our members recognize that safety is not a competitive issue, and so they have come together to share their tests that go above and beyond the required or the voluntary safety standard. So this can happen in a couple of ways. One, the groups are getting together and reviewing recalls or other incidents, the database, and looking for issues there and how they might work together to solve those through testing. And also they're just coming to the table with, hey, we do this extra test for this product to address this potential risk. And what do you all think about it? Should we put it into the voluntary standard? And the answer is pretty much always yes. And so over the past 6 years, we've made more than 60 proposals to UL and CSA for improvement of the safety standards for a variety of products. They're really averaging 10 to 12 per year there. So we've seen that as a very successful process. And then, of course, we work together with our members also to educate consumers on the proper use of their products and on the inherent risks with some of them, like portable electric heaters or tipping for ranges, things like that. So even though we don't have, specific policies we recommend to our members, we do talk with them about, what are the sort of broader high-level elements for what we would call a world-class safety system. So on the slide here, you can see what some of those are, and I'll just walk kind of quickly through each of them. So first is the organization within the company, and I think we've heard a lot about this today, that safety shouldn't be bound by sort of your traditional hierarchy and your reporting structure where it's only going up one chain, but it's more of a matrix type approach where it can start from anywhere and it can go to a broad variety of places where it needs to go. And this can be done, it should include alerts and training and communication, of course, and the proper pathways for that are critical. Also, product safety responsibility. This has to be present in more than one place. So, it has to pervade the company's culture, its functions, its policies, and its communications in order for it to be effective. So policies need to be in place for that. And I'm going to go through the next two on separate slides, but moving to the last one here on the list, going beyond the minimum, something I just talked about, really making sure you go beyond the safety standards and requirements, because just meeting a voluntary or even a mandatory standard isn't guaranteeing that you have a safe product. So looking then at, corporate consumer safety policies, what are some key elements to that? They're listed here, but I think just boiling them down a little so I'm not just reading to you from the slide here. You want to have a policy and defined procedures. Everyone in the company needs to be on board, and that starts with the senior management having ownership for it and really, sending that down through the rest of the organization. Specific duties dedicated to safety and clear goals for those duties. A disciplinary process, something maybe not a lot of people wanted to talk about this morning, but I think needs to be in place. Communication, monitoring, and training. I didn't know the slide did that. Okay. I'm guessing it might do the same thing on all of them. It didn't when I went through it. But safety also needs to be, company-wide. So that's whether you're a small company and you're in one place, maybe you're only in the U.S., or if you're a large global company, it needs to go, cross-cut throughout the entire organization. So it needs to be unified. If you're a global company, it needs to be global, it needs to be consistent, and it needs to be clear and known to everyone within the company for it to be successful. And, a little bit more, detail here. I think the bottom line is we've heard a lot of different, I think the panel before this one heard a lot of different ways to go about this. So really what we recommend to our members is just find the system that works for you, that meets these sort of high level criteria, and, not try to mimic any other company. So, maybe you hear ideas from one plan and from another that might work well for your organization, but you really need to look at the structure of your organization, the products you're selling, to be able to determine what's going to work for you. I think the key for everyone is to make resources available. So for training, for different investigations, for failure analysis, communication, and also for consultants that might be necessary. I want to touch also on recalls a little bit here and kind of their connection to compliance plans. So AHAM members, like other manufacturers, are producing hundreds of millions of products each year. And for those products, as I started out talking about, they're designing safety into the products, and for the most part, this is successful. The products that are produced are to the highest levels of quality and safety. And our members certainly, as I talked about in the beginning, have a demonstrated commitment to safety. That said, sometimes there is the need to do a recall. That doesn't mean, however, that there's been some kind of breakdown in the compliance plan necessarily. What we view that as, a number of different factors. So there could be, an indication that a firm has lots of products and, lots of different products and lots of volume of those products, and a robust compliance program. And so over the course of all of those products, there's bound to be a recall at some point. And many of these companies also have effective compliance programs. So what the compliance program is actually helping to identify the need for the recall, right? So earlier in the process, you might be identifying a potential issue because you've had this compliance program, whereas a firm that does not have a successful or robust compliance program may not be able to identify those. So I think that's important. And also, we've done a survey of consumers on, what's their view of a recall, particularly what's their view of a manufacturer who conducts a recall. And we were somewhat surprised by the results, which demonstrated that consumers actually view them positively, that the firm that's conducting the recall is seeing that the consumer is seeing the firm that conducts the recall as doing what it needs to do to protect consumers. So I think that's another valuable point to add here. And with that, I'll turn it over to Kelly.
Thank you. First of all, I'd like to thank CPSC for having us all here today and for you for spending your morning on this very important topic to all of us. Like my colleagues, JPMA does not provide specific advice on compliance programs. However, we're often a first call and seen as a trusted resource. What I'd like to do today is try to not be duplicative of all of the great remarks we've heard, but really focus on some of the unique factors of the baby products industry and the interests of the very, very small manufacturer. JPMA is the voice of the industry on quality and safety for baby and children's products in North America. We do so by advancing the interests of manufacturers, parents, children in the industry at large through product performance certification, events, consumer education, and advocacy with the goal of bringing safe, functional products to market. This is really important. We've talked a lot today about creating a culture of safety. And we at JPMA believe that not only must a company have a culture of safety, but your trade association as a resource and also the industry at large must have that culture of safety. Throughout our 50-year history, we have revised our mission statement multiple times, and you can see the current iteration, which was approved just last year as we become a more consumer-facing entity, references safety in several areas, really embedding that fact that our industry as a whole must be one focused first and foremost on safety. A trade association, and you've heard before, plays several roles with respect to its members, where JPMA sees itself positioned. Member company support and education. We provide access to expertise, including staff and outside consultants where needed, and a variety of programs and services. We educate on best practices, industry trends, and provide regulatory updates. On public affairs, we're engaged in issues, many different types of issues, provide education, and spend a lot of time just advancing the overall interests of the industry. And then our certification, which is a very important part about what we'll talk about today. Our certification program is based on product testing. It is a turnkey testing solution for manufacturers so that they can be assured that their products meet all requirements. Our program can serve as a part of a compliance program in verifying that requirements have been met, but we do not promote that it is a one-stop shop for a compliance program. For us, the most important thing about compliance programs is helping members understand the robust legislative and regulatory scheme to which they are subject. This is especially true in the case of our smaller member manufacturers. In the juvenile products industry, we have many what we call mompreneurs. JPMA represents 90% of our industry. Over half of our members are less than $5 million in sales. Particularly compelling, Manhattan Toy, certainly you held yourself out as a small company, and many of our members aspire to be the size you are. Most of these companies have 5 employees or less. So on that point, what type of advice do we give to these members, and particularly the smaller, tiny new members that are calling us up asking about compliance programs? And they do. The first thing we typically tell them is that this is a high-touch space. There is no one-stop shop. Very much they often would like to find that. There's a lot of subjectivity involved as well. So there's a human factor to compliance programs that is very, very important. We also note that in our industry, we have a variety of projects and a large number of issues that must be contemplated in a compliance program. We've heard about many of those throughout the course of the morning. But for example, in baby products, there are more than 20 federal standards that are unique to each type of product sold. So even in a large company, they may be entering a new product category that is regulated separately from what they're currently making. And in that case, they perform very much like a small company, often having to start some of these parts of their compliance program from scratch once again. Also, in baby products, certainly our ultimate customer is a vulnerable population who's engaging with the product one-on-one directly, but who's not responsible for the purchase or proper use of that product. And as all of us with children know, if they can find a way to misuse a product, they will. The other thing that we say is certainly, once you're beyond the point of knowing that this is a high-touch space and you're going to have to spend some time crafting what works for you, evaluating the level of risk is certainly important and can vary greatly among different types of baby products. Also, building a program based on trusted partnerships. And for the smaller manufacturers, this is really critical because often they will have very few of these functions in-house. Their factories and their sourcing is often shared. They use 3PLs to manage their logistics, and even their design teams are often outsourced. So we recommend that they research their partners very carefully and find partners that understand our product category, understand baby products and some of the unique elements of manufacturing and producing safe baby products. We also do refer often to the regulatory robot. We believe it's a wonderful tool for small manufacturers to get a sense of what they may be subject to in terms of federal regulation. Testing labs, it was touched on earlier. Third-party testing is mandatory for durable children's products, and the issue of using an accredited lab, we agree. We often see that sometimes a lab partner is selected that is not accredited in the children's product space, and so that's something that we very much try to call out to new members to ensure that their lab is accredited. Supply chain transparency. Again, we encourage this being heavily on pre-market versus post-market. When you don't own your production in particular, QA systems have to be put in place at the factory level to ensure that issues and challenges are caught as early in the production process as possible. Building the corporate culture. Again, we've touched on it before. In the case of the small companies that we're often speaking with, the chief compliance officer is the CEO and founder of the company. That person started a business because they had a wonderful idea and felt that they were fulfilling a need. And often regulatory compliance was not what got them into business in the first place. So ensuring that that individual understands that the step from the great idea to a viable company will require them taking on a role that maybe initially they had no idea was going to be part of their job responsibilities. Ongoing maintenance and evolution. I'll tie this discussion to our certification program, which I mentioned earlier. So in the robust regulatory scheme, and which dives into federal, state, retailer regulations in our space that are reviewed regularly and updated very frequently, our certification program is designed with its own protocol. So that protocol is reviewed twice a year and updated with a variety of different regulations. We do find that from the large to the small company, it's a great spot check. So again, it's a testing verification program, but it does encompass a wide variety of requirements that are continually updated so that the companies can ensure that they're testing to the most current standards that are out there. It encompasses things even such as registration cards, labeling, and packaging as well. And then, again, we drive home the point that testing doesn't equal compliance. And again, this concept of it being a very high-touch process with a lot of subjectivity is a very important one as well. Technology. So the role of technology, actually, we thought that this was a great question and it inspired some great internal dialogue because technology is critical to a compliance program these days. I think the question is not if, but how you use it and how robustly you engage with technology as part of your compliance program. The speed of commerce, the number of SKUs, the variety of retail outlets, and direct-to-consumer sales, which are growing as well. I mean, these things all require that you have a technological solution for tracking production and testing and your sales volume as well. So certainly, again, that's something that we encourage right off the bat is find a trusted partner, adopt a technology solution as part of your compliance program. Again, though, it's very high touch. You can't just defer to your technology solution. You have to have real humans on the phone answering the calls, making subjective judgments about when and if there may be an issue all along your supply chain. We do think that the technology, though, is particularly useful in certain areas, such as preventing late shipments, identifying testing failures, ensuring that testing is done on a regular pulse by providing alerts. It can help identify labeling issues, quality issues, identify on hold items, help eliminate rush testing charges, and in all of those ways reduce costs. So certainly, when you're providing advice to a small manufacturer, a small member, the fact that the reduced cost bit of it is often compelling and really provides the impetus to sort out a technology solution to help in this process. And then finally, communications. Again, as we touched on before, direct-to-consumer sales is a growing part of many businesses, and certainly the baby products industry is no exception to that. When something does raise a flag, it's really important that outreach is immediate, particularly with small manufacturers. Sometimes there's a hesitancy to return that tough phone call, but the outreach really has to be immediate, and it has to be a dialogue with a human to really get to the bottom of the problem. It's important to ensure that the right questions are asked and that the sample is returned to the manufacturer for evaluation. We find that the most successful compliance programs in our space do have that element. Compliance has to be viewed as circular, not linear. And often it's not just one phone call, but a variety of phone calls and a variety of people in the process that makes the communication chain really support a robust and positive and successful compliance program. To the point of reverse logistics, which we've talked about, we find that for retail and warehoused goods, that some of the plans we've heard about today are very effective at keeping goods out of the marketplace if the recall is identified early. Some things I'd just like to call out that, again, are somewhat unique to baby products that we find challenging in terms of reverse logistics are that the products are typically employed for short-term use. They're sometimes borrowed or they're removed from use, put in the attic or stored, and then brought back out for use after many years. So it's technically a secondhand product, but since it was yours, as the parent, you may not feel that way or you may not relate to the fact that it's a secondhand product. Even if the products are registered, this community is very transient, and we find that in 3 years, the data has degraded to the point that it's really not very useful at all. Certainly, online registrations and emails have helped with that, but again, if a recall occurs, getting in touch with that family, and again, if the product that may no longer be in use, can somewhat be a challenge. So we find that the best solution to that is this constant reminder, please check for recalls, please check for recalls. We hear this in a lot of places. The media have been great partners with that. CPSC makes it very easy to do so, as do a number of non-governmental entities, as well as ourselves. But getting that message out as well and encouraging parents to constantly check for recalls on their products is a very important part of the overall compliance strategy as well, that's sometimes overlooked. Thank you.
Again, my name is Kristen Kern. I'm with the American Apparel and Footwear Association. I just want to thank the CPSC again for the invitation to speak today. So not to duplicate any of the presentations that came before me, I'm going to speak to kind of the things that our members often look to us for. I think that kind of gives some insight as to the priorities of the apparel and footwear space specifically when it comes to compliance. So a little bit of background on AAFA. We represent apparel, footwear, and other sewn products companies as well as suppliers throughout the entire supply chain. We represent about 1,000 name brand companies. Those are retailers, again, manufacturers, as well as brands. And we really divide our focus as an association into kind of these 3 buckets here. So that's the brand protection, supply chain, and trade focuses. And we help our members navigate the regulatory environment, both at the domestic level in the United States as well as internationally and even at the state and local level in the United States. So our focus today on product safety falls under our supply chain work. We engage, of course, with the CPSC a lot on our product safety work, as well as state
and local level governments. We advise members on chemical management as well as sustainability, transportation and logistics, and other areas of the supply chain. So as we've talked about today quite a bit, there's not really a one-size-fits-all compliance program, but we do think that there are a number of tools and key core elements to a successful compliance program. And so you'll see here, these are a number of tools that we maintain for our members, and those all come from both member requested information as well as our suggestions for key parts of a compliance program. So these tools help members understand state, federal, and as well as international regulations that apply specifically to our industry and how to navigate them. So our first tool here is our restricted substances list. This is, I would say, one of our most notable tools, which takes all of the international chemical regulations that apply to apparel and footwear products and just puts them all in one place so that members can see what all of the regulations as far as chemical management goes that pertains to their products are, and we make sure to keep that updated so that members are able to at least use that as a cornerstone of their chemical management, and in most cases build on it in some way specific to their brand and product offerings, to use that document with their suppliers to make sure that they have some control over chemical exposures of the products that they're providing their consumers. The next couple of tools we have on here are state level tools as well as CPSA guidance, just provides compliance strategies, breaks down the laws into actionable items, and gives companies some recommendations and considerations on how to incorporate either updates to laws or new laws into their existing compliance strategies. Our recalls running list that we keep track of really just takes the information that the CPSC is already providing and just narrows it down to products in our space so that companies can track data specific to our industry, specific hazards for our products that are coming up in recalls, and just boils that data down into something that's easier to manage for companies specific to our industry. So the most important part of all of these tools is the fact that they really just take the information and boil it down to industry-specific information. Like we've mentioned, the CPSC has a number of tools that we're able to point our members to every day. So to not duplicate those efforts, we just take that information and boil it down to industry-specific information, which is a lot of what our members are coming to us for. So as I mentioned earlier, chemical management is really a key part of what our members are doing daily in their compliance programs for a number of reasons. Of course, having a restricted substances list helps companies control chemical exposures from their products, and that really requires staying up to date with science of chemical hazards as well as up to date with regulations that pertain to our industry. But of course, RSLs are increasingly being used and chemical management is increasingly being used for other areas of product safety, to include things like sustainability and worker safety, as those focuses are really growing in our space. Companies are starting to ask themselves, what chemicals are workers being exposed to in their factories, and what are the environmental impacts of the chemicals being used in the production process. So using something like a manufacturing restricted substances list is something that's been growing in popularity amongst our members, is figuring out how to control chemical exposures at the factory and production level, and not just at the consumer level, so that we can ensure that all parts of the manufacturing process as well as use of the product are safe. Of course, testing is no surprise as part of a compliance program. We like to look at it, the importance of a testing program is as verification of compliance. Sourcing from reputable producers, using a robust RSL, and designing safe products are key elements of a compliance program that come much earlier in the process and can make the testing process quite a bit easier if the compliance program ahead of testing has accounted for all applicable regulations and safety hazards. And lastly, just staying up to date with changing regulations. Regulations can change almost daily around the world, and many of our members are selling globally, and so that planning to update your compliance piece takes into consideration the fact that a compliance program written a year ago may not be up to date with all of the newest regulations. So we update our tools monthly or annually and as needed, and assist our members in doing the same, so that we can make sure that safety is evolving with new information on risks and hazards. So thank you again.
I'd like to say thank you again to all of our panelists.